I'm attorney Naun Anthony Benitez.
Attorney Ben Chaptal.
This is a Class A misdemeanor, battery causing bodily injury.
Maximum punishment for a Class A misdemeanor, which is what this was, is up to 365 days in jail or a $5,000 fine.
The facts are that my client goes to her house by herself, and inside her apartment is the ex-wife of her husband, and she's there in her room, and then a fight ensues.
So the ex-wife is in the current wife's room. The fight ensues. The state was alleging that the ex-wife got hit first, and so she was their alleged victim, whereas our defense was that no, the ex-wife actually hit our client first, and so our client was the victim, and she had every right to defend herself in her own home.
You do not have to get hit first in order to claim self-defense. So the reason the state decided to move forward, because different minds, I can come to different interpretations of the facts, but it was mostly because inside that room, there was only three people. There was our client, which is the owner of the house, the wife. There was the ex-wife, and the ex-wife brought in a child, a 13-year-old child. So the client came to our office and she said, hey, I didn't do this. In fact, she actually had already another attorney that represented her, and they were pushing for a plea. The client told me that she was innocent, that she did not want to take the plea, and I told her, perfect, we will do a jury trial in your case, and that's what we did. Yeah, I did this jury trial, and like I said, Marc Lopez Law Firm, we're a team, we're 8 attorneys. I wasn't going to go in there alone. I went with my boy, Ben. Ben did amazing. We teamed this case up. He helped me from the beginning through the end and before the case. Yeah, he did a great job.
Yeah, I mean, my first impressions of the case, obviously I got a quick rundown from, Attorney Benitez where he kind of gave me a quick summary of the fact, but then I kind of took like an outside view to make sure, I'm coming into it fresh, making sure that, there's not something that we're missing, that the state seems to be missing. And when I looked at it initially, it seemed like a case where our client's story made more sense than what the state was going to be giving at trial. And so, I think we had confidence going into the trial that our story was going to be the one that the jury ultimately believed.
So first and foremost, we sat down with our client multiple times to talk about exactly what was in there. We want to get familiar with the facts, with her side, with what happened that day. We talked to all the witnesses in this case. We talked to 3 civilian witnesses on our side. Also, we met with all the attorneys in our office met together. We talked about the case. We asked everybody what they thought, what was our weaknesses, what were our strengths. And then on another day, we met with all the staff and attorneys, again, to brainstorm this case, see what they liked, what they didn't like, what we had to explain. And it all worked out because eventually we got the verdict, not guilty.
Generally, jury trials start a little bit earlier than regular trials, so both myself, Attorney Benitez, and then the state, you show up around 8:15. You're going to initially go through some preliminary instructions with the judge. You're going to determine what those are, if there are motions in limine. Here, for example, we had motions in limine that we had to kind of argue before the trial, which is basically us arguing what can and can't be talked about. We argued that. Then you get juror questionnaires, so then you kind of pre-screen jurors. You get to kind of see their information. The jury is then brought in, or jurors are then brought in. We then conduct voir dire. Because this was a misdemeanor, we only needed to seat 6 jurors and then an alternate. So you go through voir dire, you ask them questions, try to select a jury that hopefully is going to, be favorable to our client. The state's trying to do the same thing. And then the state gets to present its case. It starts with opening arguments on both sides. Attorney Benitez gave our opening argument where he basically summarized, hey, here's what the evidence is going to show, and you're going to find not guilty at the end. The state called their witnesses, which was the, alleged victim here, her daughter, an officer that had done, some of the investigation. After that, we were then able to present our case. Sometimes you don't have to. Sometimes we can just say the state didn't meet its burden. Here we decided we have a really good story that we can put forth that's far more convincing than what they're saying. So we decided to call witnesses on our end. We also ultimately made the decision to call our client. We were able to ask her questions. We were able to get out our side of the story to show just how badly our client was beaten. And then we did a closing argument where, again, Attorney Benitez basically summarized, hey, here's what the evidence did show. Here's why the only reasonable interpretation of what you heard here today is that our client should have been the victim here. And then you give it back to a jury and they deliberate. And after a short deliberation, they were able to come back not guilty.
I think the fact that my client's story never changed. My client told the police officers on that day when it happened, her story, what happened. Then she told the exact same story in front of the prosecutors and the jury. And the prosecutor got up and cross-examined her, and she told the truth then, and she told the truth again, and she was prepared, and the jury believed her.
I think maybe the biggest thing was that the alleged victim's story here, it just simply wasn't believable. I think that for the most part, jurors can be intelligent and they can recognize when a story seems to be made up or a story just doesn't seem to flow. And here, I think that their story just wasn't a story that generally happens in everyday life. It just didn't really make sense. And then coupled with the fact that our client's story, as well as our witnesses who were giving a very similar story, it all was consistent. It made sense. And it was really the only story that seemed to logically fit what would have happened.
Great outcome for a great client. Just happy to be part of it. Absolutely.
Absolutely. Can't wait.
Remember, always plead the fifth.